set it up. Can I erase that? Or that? Can I erase it? Okay. This is our outline for today. Just to review from last class, if you remember, we talked about limited jurisdiction again, and that's we discussed the two most important types of federal jurisdiction. Does anyone remember what they were? Diversity jurisdiction and federal question jurisdiction. And then we also talked about judicial review last class, and we talked a lot about Marbury versus Madison. That was last class, okay? If you remember, judicial review is the power of the judicial branch to find laws or acts of Congress or the president as unconstitutional. So that means that the judicial branch of the government, of the federal government, can find laws unconstitutional or against the Constitution. We talked about that last class. Okay, just to review. And also, 2 classes ago, we talked about federalism. That's where we talked about the state governments, as we talked about the 50 U.S. states and how each state has its own government, its own constitution, and then we also talked about local governments, and those are city governments or county governments. That was 2 classes ago, okay? Just wanted to review where we are now. This has to do with the judicial branch. So if you look back in your notes, you can see that we were just finishing the branches of the federal government, okay? Now, I'm going to talk today more about legal education and the legal profession in the U.S., okay? Last time I talked about the JD degree. That's the law degree that lawyers in the U.S. obtain or get after 3 years of law school. And we also talked about the way that the students learn. If you remember, case method and Socratic method. That's the students in the JD programs in the U.S., they learn by studying cases. Okay, so we talked about that last class. It's also important to know that the JD programs in the U.S., they spend a lot of time on legal writing and legal research. So a lot of the students write papers, long papers, as part of their JD program. Okay? I'm going to talk some more about the LLM programs in the U.S. today. I think some of you are interested in those, so I'm going to talk a little bit about those. Okay? Okay, LLM stands for Masters of Law. And many foreign lawyers from China and other countries go to the U.S. to study for an LLM. And so many of them are very interested. Many law students in China are very interested in LLM programs. So I'm going to tell you a little bit about it, just in case you're interested in applying one day for one, okay? These LLM programs are for 1 year. We talked about that last time. They're for 1 year. And the students that get an LLM can also stay another year to work. So you study for 1 year, and then you can stay another year in the U.S. to work in a law firm or a law organization. Okay? If a U.S. student wants to do an LLM program, they have to finish a JD first. So they have to do a JD first in the U.S. to get an LLM program, but to go to an LLM program or get an LLM degree. But students from other countries just have to have their first degree in law, okay? And then they can go to the U.S. Or I think England has a lot of LLM programs too, Europe. So that's how they're usually done. The reason a lot of foreign lawyers these days are getting LLMs in the U.S. is because their clients or their law firms that they're working for are having business dealings with U.S. companies, or there's American or U.S. companies wanting to do business in China, and you or someone in your law firm is the person advising this American company what to do in China about their business. So a lot of foreign lawyers from all over the world are in the same situation. So that's why they're going to the U.S. to get the LLM degree. There's different types of LLM degrees. There's ones just for lawyers from other countries, and they're called American law LLMs. So they're 1 year of study in all American law. There's other ones that are international LLMs. So those are 1 year of study in international law. So that wouldn't just be focused on U.S. domestic law, but that would be focused on international law or international business transactions or international human rights, any of those types of international classes, okay? There's even LLMs that just focus on international business. So there's some schools, law schools in the U.S. that only have programs that, LLM programs that focus just on international business law. So some students are very interested in those programs. If you are interested in it, I have some websites that you can go to. It's kind of a long website, but that might be hard to see, but it's long, I know. But that website has all the links to all the LLM programs in the U.S. So you can go there and look at all of them. And then there's another one that has more information. That's ili.org. So those are two websites that you can look if you have more information, if you want more information about LLM programs. So what is required for a lawyer from another country to get into an LLM program in the U.S.? There's a few things. There's the TOEFL. I'll just write this, which I'm sure all of you know about. And most programs require a score of 600. on the TOEFL. And if you take the computer TOEFL, it's $250. So that's $250 computer score and $600 written score, okay? The other thing that you would need is an application, and most schools have applications online, so you can do the application online. You don't have to mail anything to them. And part of the application is usually an essay. It's usually about 1 page about what you want to do or why you want to get the LLM, or what your aspirations are. And also either 2 or 3 letters of recommendation. So that would be from a professor or someone that you worked with. Usually that's from professors. And then official transcripts from your school, and first degree in law, so like an LLB. It would be the requirement for admission. So for the visas to get to study in the U.S., the school that you apply for, if you get into that school, they will help you with your visa. So they usually help with all that. And you don't have to take the LSAT. That was the test I was talking about last time that people who want to get a JD have to take. You don't have to take that. You just need these things, okay? Usually the cost is the same as 1 year in law school for a JD. So we talked about cost last time, and it depends on whether it's a private school or a public school. And the private school is about $28,000. We talked about that. And the public school is about $20,000. So most lawyers that come from other countries to study in the U.S., they get tuition credits or tuition remission scholarships to study there, or they get it from either from the university that they're going to study at, or from the government, or from foundations or international agencies. So the thing is that students who come from other countries to study in the U.S., they can't get government loans that most JD students get. So it's better to get a scholarship, obviously, than have private loans. So I have let's see, for the cost. That's a website that has information about students from other countries who need funding to study in the U.S. Okay, so that's a place for more information. A lot of students ask me about which school to go to, which school to apply to, because which school is better, right? Well, each of the schools in the LLM programs usually have specific specialties or things that they're better at. So it would depend on what you're interested in, but if you want to know about, okay, this is about funding, but if you want to know about school rankings in the U.S. for law schools. This is the website for looking at that, and you just go to U.S. News. U.S. News does a school ranking of all the law schools, and then you, when you get to that website, you go to, it says like, I think school or education or something. Click on that, and then you'll see, it'll say law rankings, and then you can look there. It has, U.S. News ranks all the graduate schools in the U.S., like medical and law and everything. So it's for magistrate. So that's for rankings. So if you're interested in that. So the courses for a student from another country in the U.S. are usually given, the LLM courses are usually given with the JD students. So they're usually together. So that means that that a student has to be prepared to be called on in class, because they'll be using the same methods of teaching that they do for everyone in the JD program. So it depends on what kind of class it is. Usually in a lecture type class like this, they do use, the teacher does call on the students, but not as much as in a smaller class. Some of the classes are very small. They can be like 10 people in the LLM classes. So, and usually for the small classes, the students have to write a paper. So I think many of my friends in the LLM program, I was in an LLM program that was mixed for American students and students from other countries. And many of my friends from other countries, that was the hardest part of the LLM, was writing and researching long papers in English. So usually about 30 to 40 page papers they would have to write for the classes, for the seminar classes. Not single spaced, but double spaced. So it's a little bit better, but pretty long. The good thing is that the schools, the law schools in the U.S., they all the students are given passwords for Lexis and Westlaw, which is the computer research system on the internet. So all the students are trained on how to use the computer research, and that makes it much faster to write the papers. Let's see what else. The other thing that I found a lot of my friends from other countries had difficulty with was the reading. There were usually some teachers in U.S. law schools will give a lot of reading. They'll give about 30 to 60 pages of reading per class. So that can be quite time-consuming for students to read all that. It's time-consuming for any student, so it's always a lot of reading. Sometimes it can be very difficult to keep up with all the reading. Okay. Some students have, but I mean, it's still completely. I'm telling you all negative things, but all my friends who did it very much enjoyed it, and they had a good experience. Okay. Some students ask me, what's better, a JD program or an LLM program for a person from another country? I can't tell you which one's better, but I can tell you the differences between the two. This one, as we talked about, is 3 years. So, and this is 1 year. So, this one is more in-depth. So it's very focused. It's the same training that American lawyers receive. So it's very focused on U.S. law and training for U.S. law. So it's more for someone who wants a very in-depth knowledge of U.S. law. And then the LLM it seems that more lawyers from other countries are attracted to this because they're working at a law firm that does business either in the United States or has a client who has dealings with someone from the United States. So they seem to be okay with the LLM degree to do that, okay? The other thing that's different between the two is that for the JD degree, if a person gets a JD degree, they can take any bar exam in the U.S. But for LLM students who are from other countries, they can only take the bar exam in certain states, only 10 states. Okay? So I'll talk about that a little bit more in a minute. But let's see. Usually, to get your degree, your LLM degree, you have to take 24 credits. That's what and a credit is 1 hour of class. So that equals about 12 credits per semester for 1 year of studying, okay? And usually the students are free to choose any classes they want, except for students from civil law countries like China or France or Germany would have to usually take a class in American law. So they usually have to take an introduction class. And I think all students usually have to take a legal writing class that first semester, right when you get to the U.S. And then after that, all the students are allowed to choose whatever they're interested in, okay? Let's see. I mentioned a minute ago about the bar exam, that all LLM graduates from other countries cannot take all the bar exams in all the states. And I said there's 10 states. So there's 10 states that didn't take the bar exam. So the most popular one, each one of those states, those 10 states, has its own restrictions and rules. But I think the most popular one is New York. Most students who do LLM programs from other countries take the New York bar exam. Usually what they do is they come in September and they study from September to June in their law school. That's 1 year of studying. And then in June and July, they study for the bar exam in New York after they graduate. Okay? You don't have to be a U.S. citizen to practice law there. So if a person does an LLM degree and they pass the bar, and they're allowed to stay 1 more year under U.S. immigration law and work at a law firm, they can practice like any other lawyer. Okay? There's also one good thing about law schools in the U.S. too is that they usually have a lot of career services. So they have a whole office that's designed just to help the students find jobs and understand what kind of jobs they want to do. So some schools like Washington College of Law have one person just dedicated to helping LLM students from other countries find jobs in the U.S. For their 1 year of training. So some of those schools have very good, they're called career services to help them with finding jobs. Okay, last time I talked about the bar exam. If you remember, it's 2 to 3 days, and we talked about the pass rates. One thing I wanted to mention about that too is that after the students pass the bar exam, they have to go through what's called a character evaluation. Write that on the board. So that's where the Bar Association in the state that they apply for, like New York, will examine the person's character, and what they do is they investigate all your finances, all your financial status, and they contact people in your life. So, like for me, for example, I went through the character evaluation in Georgia, so I had to give them all the places I lived for the last 10 years, all the 10 people that knew me well for more than 5 years, kind of like an investigation. They investigate. The reason they do this is because they want to make sure that no criminals, like a convicted felon, a person who is convicted of a bad crime, or if there's somebody who doesn't pay any of their debts, then usually they won't be very responsible for being a lawyer. So that's why the people at the Bar Association do the character evaluation. Okay, so the next thing I'm going to talk about is, but anyway, just one more note about this, is that most people pass it. Most people don't, they can become lawyers if they pass the exam and they are truthful on the character evaluation, okay? Now we're going to move on to the legal profession, okay? So, let me erase this. Okay. Now, before I start talking about the types of lawyers there are in the U.S., I want to talk briefly about the role of law in U.S. society. The law plays a particularly important role in U.S. society. The law has been instrumental in, or important in, civil rights. It has dealt with the allocation or the spread of political power. The law has had cases that deal with the creation of life and its termination. So, like cases that deal with abortion or right to die or capital punishment. So the law is very important in the U.S. society, and the reason that people accept the law as being so important is not because they like lawyers or that they admire judges. It's because there's a respect for what's called due process of law. So what that means is that people in the United States are very interested in solving problems by process, by procedure. So it's not about the result. It's about whether the process was followed. That's why in the U.S. there's so many rights that are protected in the Constitution, in the Bill of Rights. It's because the framers or the writers of the Constitution were very concerned about process. They wanted to make sure that everybody got the same treatment in the system, the legal system, okay? So that's what the rule of law is in the U.S. The rule of law is very important, and that's because of the process, okay? So this process or following of legal procedures was formed, the lawyers in the U.S. Played a big role in forming process in the U.S., and they have been defending it and preserving it, and even reforming it, changing it. So that's why lawyers are such a big part of U.S. society, is because process is so important there, and lawyers are such a big part of that legal system. Okay? So now let's move on to talking about types of lawyers. Okay? Now, being a lawyer in the U.S. means a lot of different things. There are trial lawyers that go to court. Those are the ones that you've seen in movies, like Philadelphia, those kinds of movies. Those are what we call trial lawyers, people who go to trial, go to court, okay? And those are the ones that are often in court appearing before judges and juries. There are some lawyers in the U.S. that don't ever see the inside of a courtroom. For example, they're called partners in law firms that have lawyers, 500 to 1,000 lawyers, and they represent corporations, and they never see the inside of a courtroom. They're always doing paperwork for the corporation, or working out legal problems like contracts or other types of things, and they never go to court. There's also lawyers that work for the corporation inside of it, like they're called general counsel lawyers, and those are lawyers that are part of the company, like Buick or GM. That company has lawyers that just work for them in their company, and they hardly ever go to court. Then there's lawyers who practice alone. They're called solo practitioners. I will talk about them more in a minute. But they're people who usually help families or small businesses with divorces or wills, property problems, and disputes, small disputes, like with neighbors or someone like that. Those are like lawyers who work by themselves, okay? And then there's lawyers who work in small firms, just like 5 to 10 lawyers together. They'll form a firm, and those lawyers also do the same type of work. Okay. Then there's lawyers who represent people in serious trouble, like victims of accidents, people who got in accidents, car accidents, or a doctor didn't treat them properly. Then there are those type of lawyers. And then there's also lawyers who help people who are accused of crimes. Okay? So when we talk about lawyers, often in the U.S., a lot of people get the image of lawyers in the courtroom, in front of a jury or in front of a judge, like you've seen in the movies before. But usually, the majority of lawyers don't go to court. Okay? So let's talk a little bit about the types of lawyers that I was just mentioning. Okay. The first type is private practice. Those are the lawyers that work for either families, small businesses, or even corporations. They're called private practice. Most lawyers are private practice lawyers. That's about 72% of lawyers in the U.S. or private practice. And there's small firms, mid-size, and then there's large ones. Okay, for small firms, that's usually 1 to 10 lawyers. Mid-size is about 10 to 75. And large is about 75 plus. Can be up to even 1,000 lawyers. So they're all grouped together in these firms, and they work together in partnerships. They represent clients from families, like I was talking about, to small businesses, and then large firms usually represent big corporations, like McDonald's or KFC. We go to a large firm to get any of their legal problems, okay? Then the second type of lawyer that we talked about, before I move on, I wanted to say something about them, is that they make the most amount of money of lawyers in the U.S. Their salaries range from $50,000 to about $125,000 per year. That's starting, first year out of law school. The big firms like the big firms in New York or Washington, D.C. or Los Angeles, they pay $125,000 for their lawyers the first year out of law school, okay? So they make a lot of money. That's just the first year. So as they stay with the law firm, the lawyers, as they stay, they make more and more money each year. They get higher and higher salaries. So I think by usually the 5th year, they're making about $200,000. So, okay. Then the second type is in-house counsel. Okay, that's the type of lawyer that works in a corporation. So, like a big corporation, all the big corporations have in-house counsel, but they don't just have one lawyer that works inside. They have many, many lawyers that are in their law department of the corporation. Okay, so like my example, McDonald's has a lot of lawyers that just work at McDonald's. Okay. Those are called in-house counsel. So you may see that, again, if you ever have dealings with a company from the U.S., that you may be dealing with their in-house counsel. But a lot of times, in big corporations, they send some of their law problems to in-house counsel, but if they have like a lawsuit or a case, then they may go to a law firm instead, okay? The third type, these are just the major types. There's a lot of different things lawyers can do, but is government. There's the top lawyer in government service is called the Attorney General, and he's the one who heads the Department of Justice. That's one of the agencies in the federal government as part of the executive branch. So the top level, one of the types of government lawyers is a federal government lawyer. So that would mean someone who worked at the federal level, the national level, works in Washington, D.C., and works at what's called the Department of Justice. Okay. There's also other federal lawyers other than the Department of Justice. Remember that last time you got that chart with all the agencies, every one of those has lawyers that work there. So that's just one example, I should say, Department of Justice. But all of the other ones, like the Immigration Service has lawyers, the Environmental Protection Agency has lawyers. So all these different agencies of the federal government have lawyers that work there, okay? Then there's state lawyers. Those are lawyers that work for the state government. Those lawyers do all kinds of work for the state that are civil problems, not criminal. We'll talk about those lawyers in a minute. I think I'm going to have to move over here. Can I raise? No? Okay, so another type of government service lawyer is a prosecutor. So prosecutors are the ones who bring the cases against the criminals, people who are charged with crimes. Okay? They're either at the state level or the city level. There's different types of prosecutors, but most crimes in the U.S. are with the prosecutors at the county level of government. Some cities have, like New York City, because it's such a big city, has a big prosecutor's office. Okay? And they make about, out of law school for the first year, they make about $50,000. They don't make that much. They make about $50,000 in comparison to the private people. The fourth type I'm going to talk about is public interest lawyers. And that's the type of lawyer that I am. In the U.S., they have this thing called the Legal Services Corporation. And that funds legal aids in all different areas of the U.S. So usually we call this legal aid. Legal aids give free legal services to poor people. And I worked for one for 4 years. That's what I did when I finished law school. The other type of public interest lawyer is usually the legal aids do, sorry, I didn't say, this is all civil law, okay? That, if you remember from the first day, civil law is private disputes, not criminal cases, okay? And then there's the public defender. That's another type of public interest lawyer. They are the ones that defend people who've been accused of crimes. So they're the ones who deal with they're the ones who represent people for free who have been accused of crimes. Okay, that is a right under the Constitution. It's the Sixth Amendment. Okay. The Sixth Amendment of the Constitution guarantees the right of a person who has been accused of a crime, the right to have a lawyer. Okay? So if a person was arrested by the police and didn't have the money to get a lawyer to help them in their defense, then they get a public defender lawyer, and that person represents them for free because it's a right that's guaranteed under the Sixth Amendment. Okay, so everybody who's been accused of a crime, that crime could result in jail time, meaning that they could go to prison. Then they get a lawyer. Okay. And the third type of public interest lawyer is private public interest. I know that's kind of weird, but those are lawyers who work for national organizations like the ACLU or other types of non-governmental organizations. The ACLU is the American Civil Liberties Union, and it's a national organization that brings lawsuits against the government or other people who to protect the rights under the Constitution and people's civil rights. So there's lawyers that work for that. They usually do kinds of cases that will have an impact on the whole country, or a whole area. They're trying to make a difference in a lot of people's lives. But these types of lawyers are just usually trying to help one person, one or two people. Do you see what I mean? These are more lawyers who are trying to represent a whole group of people and get something changed. Okay? And these lawyers, public interest lawyers, make the least amount of money. Usually they make about $30,000 to $40,000 when they leave law school, okay? The first year after law school. The reason it's so much less is because these organizations, legal aid, public defenders, and private public interest, they usually don't have that much money to spend. But these people, the large law firms, have more money to spend on their lawyers because they're representing large corporations, so they have more money. But most of these lawyers are, all of them represent for free, so that's why. And where they actually do end up getting most of their money is there's the Legal Services Corporation, but most of it is from private people who just give money to these organizations, or if it's the public defender, the government pays for that. Okay, so that's why they don't have that much money, is because they're dependent on other sources of money to run their organizations. Actually, a lot of large law firms, for example, in Atlanta, where I lived, gave quite a bit of money to legal aid. So a lot of the lawyers who work at these large law firms give a lot of money in charity to legal aid, okay? So, and sometimes they have, a lot of the lawyers from these large law firms will volunteer their time and take one or two cases to help someone. And they call that, I don't know if you've heard that before, but it's called pro bono. And that's taking a case for no money just to help someone because you want to make a difference. Okay, take your break. We'll back in 10 minutes. Okay, the next topic I'm going to talk about regarding the legal profession is legal ethics, okay? Legal ethics in the U.S. are rules regulating lawyers' behavior, okay? The reason I'm talking about this under the legal profession part of the lecture is because it's a very important part of being a lawyer in the United States. It's following the legal ethics. So what this means is these are rules that deal with lawyers' behavior. Basically, these are rules about the general conduct of lawyers when they represent a client, when they deal with the client's case, and if they do anything wrong in the case, it has to deal with legal ethics. Okay? So it's important in the U.S. because it's a required class. It's a required subject course to take in law school in the JD program. And it's also one of the parts of the bar exam. It's one of the days is on legal ethics. Okay? And the reason that legal ethics is so important is that it protects the public, private people, from abuses by lawyers, it makes lawyers follow a certain rules so that they don't take advantage of the public or private people. Okay. The conduct of lawyers in the U.S. is regulated by 3 sources. Okay. Okay, the first source is the judicial branch, meaning judges and other people that work for the judicial branch, regulate the conduct of lawyers through rules about how the lawyers are supposed to act in cases. Okay? So they're usually the ultimate or the final power of regulation. Okay? What this means is if a lawyer handles a case improperly or handles it in a wrong manner, then the judicial branch of the government, usually the state government, can disbar. It's called disbar in the U.S., meaning they can take away their bar license. They can suspend a lawyer. So usually the judges have the power to tell if a lawyer handled a case improperly or did something wrong, didn't follow these legal ethics rules, then they can take away their license. Okay? They can also, if a lawyer does something wrong in court, with their case, then a judge can say they're in contempt of court. That means that they've done something wrong in court. And that's another power that the judicial branch has over lawyers. Okay, the other source of regulation is the organized bar. The state bar associations, each state has a bar association. Some of the time, every lawyer who practices in that state has to be a part of that bar association. Okay, and that bar association handles complaints about lawyers. So that means if I did something wrong in my case and my client thought I did something wrong, then they would usually complain about me to the organized bar association. Okay, I should put that association down there. Okay, and these are the state bar that I talked about. Associations, or there's also the American Bar Association, but that's not a mandatory bar association, meaning that not everybody belongs to the American Bar Association. It's just an organization that is very concerned about legal ethics. Okay, so let's talk a little bit about the American Bar Association. Are you done with this one? So the American Bar Association started in the 1800s, and they really, what they wanted to do, this group of lawyers, is regulate legal education and regulate the way that lawyers act towards their clients. Okay, so they have a strong role in legal ethics in the U.S., okay? So what they did is that they came up with the different types of rules, but the latest rules that they did in 1983 are the model rules of professional conduct. So those are the rules that most states have adopted, meaning that almost all the states in the U.S. use the model rules. There's also another thing called the model code, but we'll just talk about the model rules for now. So the ABA wrote these rules, and then each state in the U.S. made it a law in their state, okay? So they adopted these rules. I'll just put up there the model code just so that you have it. If you're ever interested in looking at it, the other one is the model code, okay? Some states still do the model code even though it's the old one, all right? Model Code of Professional Responsibility. Okay? So that's the old rules. Some states still follow the model code. Some states, most states follow the model rules. Okay? So these are the rules that were adopted by states. So the organized bar in most states will enforce these rules. Okay, we're going to talk more about the rules and what these rules are in a minute, okay? So probably wondering what the rules are. But before we go on, I just want to say one more way that lawyers are regulated in the U.S. are malpractice, lawsuits. Those, it's kind of an indirect way, but those are cases brought by clients against their lawyers because they didn't do the right thing in their case. Okay? But usually it has to be that the lawyer acted very bad in the case. Because to win a malpractice lawsuit, meaning the client brings a case against his lawyer saying that you didn't do a good job for me, okay? In order to win it, he has to show that the lawyer was at fault, and he has to show that if it wasn't for the lawyer's bad job, then he would have won. He would have won his case. So those are kind of difficult cases to have. The client has to show in his case against his lawyer that he had a good case in the first place. Okay? So those are usually difficult to win. But still, most lawyers in the U.S. have malpractice insurance. So if you work at a law firm, you usually have to... could you stop talking back there? I'm trying to do the lecture here. Usually, most lawyers have malpractice insurance, okay? So that is to protect them. If they do get in trouble, then an insurance company will help them with their problem, okay? So those are the three ways that most lawyers are regulated in the U.S. So let's talk a little bit more about legal ethics, what it means, what those are, what those rules are, okay? These two things, the model code and the model rules, they set forth guidelines in the way that lawyers are supposed to act with their clients and the way that they're supposed to act with other people for their clients, and also the way that law firms are organized. Okay, so these rules set up, they talk about those different types of things. So they're very important. Let's just talk about one example. The first thing I said was the way that a lawyer acts towards his client. Okay, and there are certain duties, the big duties that a lawyer has to his client in the U.S. Okay, so let's talk about those. Duties to clients. Okay, so that's one of the main areas that we can talk about. The main rules, most important, I would say. One of them is the duty. Okay, one of the main duties that a lawyer has to his clients is the duty of competent representation. Okay, so that means that the lawyer has to have the knowledge, the skill, and the preparation necessary to represent their client. Okay. So that means they can't, let's use an example. If a business lawyer wanted to take a murder case, he doesn't have any, usually he wouldn't have any skill or knowledge about criminal cases, right? So if he wanted to take it, he shouldn't do it. One thing is that he could just say, I can't do it. I don't know anything about murder cases. I'm a business lawyer. The other option is he can find another lawyer that does know about murder cases, and they can work together on the case. Okay? So that's one of his ways he can become competent. The other way is he can educate himself. So he can just study and learn everything he can find about murder cases and how to do them and how to try them, and then he would be competent. But it's just important to remember that the duty to provide competent representation, that the lawyer has that duty, okay? Another duty that lawyers in the U.S. have to their clients is a duty to consult. Okay? Consult means to talk to. Okay? He has a duty to talk to his client and follow his decisions. So sometimes, let's say for example, that there's a lawyer who's representing a person accused of a murder. And he thinks that the best thing for him is to say that he's guilty and get prison for 10 years. The lawyer thinks this is the best deal for him based on what's going on in the case, okay? But the client says, I didn't do it. I don't want to plead guilty. I'm innocent, okay? Then the lawyer can't just go ahead and say he's guilty to the judge. He has to follow what the client wants, okay? And the other way that this usually comes up usually a lawyer would never go against the client that much, but sometimes when you're in a case and you are negotiating the case and you want to come up with an agreement with the other party in the case, then usually the other side will say, we're going to settle for this amount of money. And sometimes the lawyers will forget to ask their client whether that's okay, you know? They'll go ahead and say, no, we want more, or something like that, you know? So it's just, that's one of the important things that lawyers in the U.S. have to remember, is that they have to consult with their clients on decisions. And even if they disagree with that decision, they have to follow it, okay? All right, the next duty we can talk about is the duty of diligence. Sorry. Okay, that means that the lawyer has to act promptly. The lawyer has to take action for the client and represent them in a timely way. So the time that this comes up in is sometimes in the U.S. There's what's called the statute of limitations, meaning that if you have a case, you have to usually file it with the court within a certain amount of time, like 180 days, for example, or let's say 60 days or something. Sometimes lawyers forget to file their client's case in the time because they have so many other cases going on at the same time, and that would be a violation of the duty of diligence, because no matter what, they have to have reasonable, it doesn't have to be unreasonable, like if something unreasonable happens, but they have to be reasonably diligent in their client's case. So even if there's public opposition to their case, or if they have personal problems, the lawyer has personal problems, they still have to be diligent, reasonably diligent, okay? The fourth one we can talk about actually, maybe I'll just do it over here. It's better. Do you need this anymore, or? Okay, the fourth one is the duty to charge reasonable fees. Okay, these are the main ones, but the fourth one. That means that the lawyer is supposed to charge a reasonable amount of money for their case. Okay? Most of the time, actually pretty much all the time, the fee arrangement or the amount that the lawyer is going to charge in the case has to be in writing. So when a client goes to a lawyer's office in the U.S., they sign an agreement saying how much it's going to cost for that person to represent them, okay? And they also usually sign what's called a retainer agreement, but we can talk about that more in another class. They're just supposed to charge a reasonable fee. The thing in the U.S. that a lot of lawyers have is what's called a contingent fee arrangement. I'll just write that. It doesn't have anything to do with legal ethics, but it's just interesting. That's where if I am representing a client who is in a car accident and they come to me and they don't have any money, but they have a really good case against the other driver for their injuries, then I can, sorry, this is all one word. This isn't very close together, but it's all one word. I can have a contingent fee arrangement. That means that I can say, I'm going to take your case and I'm going to work on it, and if we win the case, if we win the money, then I will collect my fee. But if we don't win, then I don't collect anything from you. And usually those are 1/3 of whatever the person wins. So in my car accident example, if I won, $50,000 or $100,000 for a client, then I would get 1/3 of that as their lawyer, okay? Which can be quite a bit of money. So that's why lawyers do this, even though sometimes they don't win, right? Sometimes they lose, but they usually won't take a case on a contingent fee arrangement unless they think it's a good case that it's going to win, okay? But the lawyers are not allowed to have a contingent fee arrangement if it's a criminal case. That kind of makes sense because it's not guilty. It's not any money involved, and you can't really have your fee contingent or based on whether a person goes to jail or not. That seems unethical. And then other types of cases are family cases. So if I was representing a client in a child case or a family case, divorce case, I couldn't ask for a contingent fee arrangement. Even though we may still win some money from the other side in the case, it wouldn't be allowed because it's family cases and criminal cases. They don't allow this contingent fee arrangement. It's usually only used in personal injury cases, like the one I was talking about, like accidents, that kind of thing, okay? All right. Another duty that a lawyer has in the U.S. to their client is a duty of loyalty. That means that the lawyer is supposed to represent the client and not have any conflict of interest, meaning that the lawyer can't have a personal interest in the case, in what happens in the case, okay? So another way to talk about the duty of loyalty is if, let's say, I represented a husband in a case, in a previous case, and then later the wife comes to me and wants me to represent her. I would have a conflict, right, in my loyalty. So I can only represent one side. I can't represent two different sides in the same case. Or even if I represented the husband maybe 5 years ago, but it was something that has that would conflict with me representing the wife now. Does that make sense? Like even if it was in the past, I still have a duty to my client not to represent his wife. So let's say I represented the husband like 5 years ago, I couldn't usually represent the wife now, okay? So because there's a conflict. So I have a loyalty, even for past clients and current clients, okay? And then one of the most interesting ones is the duty of confidentiality. Okay, a lawyer in the U.S. may not tell anyone about what's going on in his client's case without the client's consent. That means I have to, if my client tells me something, I can't go tell it to anybody else, not even my husband, okay? It's a duty of confidentiality. That means that what the client tells me is secret, and I have to keep it secret. The reason that they have this duty of confidentiality is because they want clients to be able to tell their lawyer anything that will help with their case. They don't want let's say I was working on a murder case, and the client was scared to tell me something because he knows that I can go tell anybody else about it, right? Then he wouldn't be truthful with me about his case. He would be scared to tell me what happened. You know, maybe he did murder the person, or maybe he had some other information about some other crimes that he committed, or something like that. But he would be scared to tell me if he knew that I could tell anybody, right? He'd be scared to tell me because he wouldn't want anybody else to know. So that's why they have the duty of confidentiality, so that a lawyer in the U.S. represents their client without the client being afraid that what they tell their lawyer will become public, or that people will find out about it, okay? But if certain things, you can ask your client, is it okay if I tell about this? So in my cases at Legal Aid, I worked with a lot of clients who had HIV or AIDS. So I would keep that secret. I wouldn't tell, who, such and such has AIDS, right? Because it was their secret that they told me. But if I asked them, can I tell somebody about that because it's going to help in your case for discrimination, for example, then usually everybody knew about it by then, but then if the client said it's okay, then I can tell, right? So it's up to the client, this confidentiality. Okay. Now, it's kind of interesting because sometimes lawyers will get information from their clients about something they're going to do, like they're going to commit a crime or murder someone. Like some clients will come to their lawyers in the U.S. and say, I'm about to kill my wife, or something like that, okay? What does the lawyer do? He has this duty to keep everything his client says secret, right? Well, in the rules, in these the model rules, it says that you can tell the police if someone is about to be killed or if someone's about to be hurt very badly, okay? But you don't have to. So it's up to the lawyer. So some lawyers won't tell. For example, in a different kind of situation, I think example that they usually tell is there was a client who had murdered two women, who had killed two women, and the client had told his lawyer where the bodies were buried, where they were, where he had left them after he murdered them. And the client, the lawyer, the father of one of those people, the father of one of the murder victims, thought the lawyer might know something about where his daughter was buried. but the lawyer couldn't tell him, even though the father wanted to know so desperately, and asked and begged the lawyer to tell him where his daughter was so that he could bury her properly. But the lawyer couldn't tell. So sometimes it can have a very sad effect. You know, it's an important duty of a lawyer, but sometimes it doesn't mean that what happens is the right thing or the most compassionate thing. So I think sometimes, a lot of times in the U.S., lawyers have a bad reputation because of these rules, actually, a lot of times. They seem like very good rules to have, right? But the reason that they have it is that the other person affected by it usually doesn't like the way that they're being treated by the lawyer. Like, for example, the duty of diligence, the lawyer is working very hard on their client's case, but the other side of the lawsuit, he doesn't like it, right? Because the lawyer's being filing the lawsuit or suing someone. So sometimes the lawyers can have a bad reputation because of some of the things that happen here. But they're very important in the system in the U.S. because of the way it's set up, because it's an adversary system, meaning that there's a lawyer that represents one side and there's a lawyer that represents the other side. So because of that, these rules are very important so that the lawyer can do the best job. They can do the best job for their client. That's why they have these rules, okay? Let's see. There are some other ethical rules that a lawyer has to other people other than his clients, and that's to the administration of justice, to the judges, and to the court. Lawyers in the U.S. are referred to as the officers of the court sometimes. So the most important duty that a lawyer has to the court is the duty of candor. That means that they're supposed to be truthful in the court. And the main one of those duties is duty of candor. Okay, that means there's other things other than being truthful. The lawyer in a case can't help his client lie to the court. That's called perjury in the U.S., to lie to the court. And what that means is, let's say I have a case and my client, right before we're about to go into the court, my client says, I'm going to lie about everything in my, what happened in the case. So he's saying he's going to go in front of the judge and lie. Well, I can't help him do that. I couldn't ask him questions that help his lie. So basically that means is that I can't help him lie to the court, okay? Doesn't mean that I have to go tell the judge that my client is lying, because I do have the duty of confidentiality. But it means that I can say, I can't just help him tell his whole lie to the court, like ask him questions that help with his lie. So that's what that duty of candor means to the court. The other thing is about the duty of candor is I have to tell what the correct law is. So in the U.S., because they follow case law and different types of law, the judge isn't going to know necessarily every type of law that has to do with the case. But the lawyers have to tell the judge the correct statement of the law, because if they tell them the incorrect statement, then it's a violation of their legal ethics. Okay. Then there's one other type of duty that a lawyer has, and that's duties to the profession. And that would be not representing a client or talking to a client, who is represented by another lawyer. So if I come across somebody who says, I really don't like my lawyer, he's doing a bad job, can you help me? Let's talk about my case, et cetera, et cetera. They're trying to tell me everything about their case. I have to say, I can't talk to you because you're being represented by another lawyer. So you have to get permission. I have to get permission from your lawyer to talk to you, okay? Okay, so that's an example of that. The other duty to a profession may be just the example I used of how the law firms are set up. So it's just another example, but the rules are pretty detailed about the way that lawyers, these are just some examples or kind of a brief outline of these duties that lawyers have, but the model rules and the model code are very detailed about how the lawyer's supposed to act, okay? I think, just tell you one more thing. There's another ethical rule in the U.S. about advertising, lawyer advertising. It used to be in the U.S. that before 1977 that you couldn't advertise if you were a lawyer. You could only, if you had a law office, you could only put your name on the door or in the phone book or something, but you couldn't put a television ad, or you couldn't have a magazine ad or newspaper advertisement saying that I'm a lawyer and I work on family law or something. You weren't allowed to do that. But after 1977, the Supreme Court said that that was unconstitutional. That lawyers are supposed to, they're able to advertise that they're lawyers, but they still can't. They still have to be truthful in their advertising, so they can't say like, I'm the best lawyer in the world and I've won every case and I'll win your case for sure and that kind of thing. They can't do that. They can't be misleading, like you're going to get $200,000 no matter what in your case. Can't do that. And the other thing they can't do in the U.S. is that you can't solicit clients. The clients have to come to you. So let's say I was a personal injury lawyer, meaning I worked in car accidents or other types of injuries. And I heard that somebody got in a bad car accident and it was the other person's fault. And I was like, well, that would be a great case. I should call them up and ask them whether they want me to be their lawyer. I can't do that. I'm not allowed to do that. They have to come to me if they want me to be their lawyer. And I can't even write them a letter or anything, just saying like, please let me be your lawyer, that kind of thing. Can't do that. Okay? That's it for today. Next class, We're going to talk about common law systems, meaning here in China you have a civil law system, and in the U.S. they have a common law system, meaning they follow case law, and we're going to talk about that next class. Okay? I'm going to go wash my hands. Oh.